Because there have been continuous debates since that, for and against, all manner of discussions and reviews of that particular judgment. So, do you think that judgment has affected people's confidence in the judiciary? And how would you describe what really transpired on that day of the judgment?
Well, even before the judgment, we have seen large segments of the populations of this country tending to lose faith in the judiciary. We have to believe in our institutions. As a nation, we have to believe in the constituted authorities. If we don't have faith in the institutions, then we might as well forget about building a nation. But this conviction, this very conviction of MAZI NNAMDI Kanu, and the sentence itself being so cruel and unusual, I think affected the judiciary in much negative and adverse way than any judgment or verdict that has come out of Nigerian judiciary in recent times. And when people say that they have lost faith in the judiciary due to one thing or one conviction or one judgment or the other, and they cite this one as an example, you have to exhibit an understanding of where they are coming from. I think they are saying that the judiciary itself is not even infallible. Even the Pope himself is not infallible. The judiciary can be hoodwinked by an artisanal prosecution that may tilt the scale of justice in the wrong way. We have seen some questionable convictions or questionable verdicts. MAZI NNAMDI Kanu's own is not the first. If we pedal back to the 1960s, Obafemi Awolowo, Chief Obafemi Awolowo of blessed memory, was convicted of treason. You convict a man of treason, a man that bore no arms, a civilian. He was convicted in the 60s of treason and imprisoned. And a lot of people also had expressed loss of faith in the judiciary stemming from that very conviction. And that conviction convulsed the system. It convulsed Nigeria all the way to 1966, when it contributed to catalyzing the first coup that we had in this country. So society has to be very careful and circumspect in handling trials of this nature that have tendencies of having a more of political colorations than judicial colorations or legal colorations. I made it clear from the very beginning, in 2021, when MAZI NNAMDI Kanu was renditioned, that rendition itself demonstrated stark evidence of a high political interest in his case. And that was why, when I was lead counsel between February 2024 and February 2025, I took very strong muscular steps to make sure that that trial did not happen unless certain issues were resolved. The first issue was the issue of his bail. The Supreme Court has criticized the revocation of his bail, and in fact, the Supreme Court went as far as stating that the revocation of MAZI NNAMDI Kanu's bail evidenced some partiality or raised questions about the impartiality of the judge who revoked the bail. So, pivoting on that, I wanted his bail to be restored as the first test of the impartiality of the judge, as the first test of the justice of the case, as the first demonstration of fair play by the court. It was a test, but the court refused, and that put some fear in me as to whether the institutional deck had been stacked against MAZI NNAMDI Kanu. The second one was my objections to his trial. As a lead counsel, I had objected to the authority of the court to try him. That the Supreme Court sent back his case to the High Court did not give a whole-scale authority or jurisdiction to the High Court to subject him to trial without objection. There were issues in his case that needed to be resolved first before we put him on trial. Issue of jurisdiction had to be resolved. So when it was denied, I went to Court of Appeal. So the case was pending on Court of Appeal, before the Court of Appeal, before we were debriefed by him, and Chief Kana Agabi was brought in, and that was how the trial commenced.
All right. From your own perspective, just like many other Nigerians,